My dear friends, on July 12, 2024, Mr. Arvind Kejriwal, the Chief Minister of Delhi, got interim bail in Delhi liquor case. My dear friends, while granting interim bail to Arvind Kejriwal, Supreme Court has made certain observations with respect to Section 19 of the Prevention of Money Laundering Act, that is the power to arrest. While observing about Section 19 of the Prevention of Money Laundering Act 2002, the Supreme Court bench comprising Lordship Justice Sanjeev Khanna, Lordship Justice Dipendra Datta has made a clear observation as to the statistics with respect to number of cases pending before Enforcement Directorate. They clearly said while deciding the Kejriwal's bail application. My dear friends, the bench noted that as of January 31, 2023, total number of ECAIRs registered by Directorate of Enforcement is about 5,906 ECAIRs. 5,906 ECIRs, that is Enforcement Case Information Report, ECIR. Out of 5,906 ECIRs, only 531 ECIRs searches were conducted. However, search was conducted only in 531 ECIRs by issuing 4,994 search warrants. It also highlighted the total number of ECIRs recorded against. It also observed very clearly that total number of ECIRs recorded against ex-MPs, MLAs and MLCs was 176 ECIRs. Number of persons arrested is about 513, whereas number of prosecution complaints filed is 1,142. I quote in exact words of the bench. The data raises a number of questions, including the question whether Directorate of Enforcement has formulated a policy when they should arrest a person involved in offence committed under the Prevention of Money Laundering Act 2002. The bench clearly observed on it. While the judgment authored by Lordship Justice Khanna added, we are conscious that the principle of parity and equality enshrined under Article 14 of the Constitution cannot be invoked for repeating or multiplying irregularity or illegality. If any advantage or benefit has been wrongly given, another person cannot claim the same advantage as a matter of right on account of the error or mistake. However, this principle may not apply where two or more causes are available to the authorities. The doctrine of need and necessity to arrest possibly accepts the principle. Section 45 is followed up with Section 19 because while granting the bail, the necessity of arrest is looked upon to see Section 45 primacy opinion of the DOE when it comes to grant of bail. DOE should act uniformly, consistent in conduct, confirming one rule for all. My dear friends, this is a very important observation provided by Lordship Justice Sanjeev Khanna and Lordship Justice Dipendra Datta. Because now the arrest under the Prevention of Money Laundering Act 2002 has become routine in many of the cases. This observation by the Supreme Court is a very significant observation. Considering the fact Section 19 works with certain principles. The Section 19 presupposes a condition wherein there should be a material in possession and that material in possession should lead to reason to believe. And reason to believe cannot be a mere suspicion. It should be a concrete evidence where when they are arrested, it should be recorded whether he will be guilty. That's a kind of a section that Prevention of Money Laundering Act has brought in under the legislation. Considering this fact, Supreme Court has referred Section 19 to the Constitutional Bench. Section 19 subsection 1 mandates material in possession which leads to reason to believe. When reason to believe has to be concrete, mere suspicion cannot be the basis for arrest. So, reason to believe has to be taken into consideration while arresting under Section 19 of the Prevention of Money Laundering Act 2002. My dear friends, this is a very important observation brought by the Supreme Court. I am very sure in the days to come, many applications will be filed before the Constitutional Bench questioning Section 19 of the Prevention of Money Laundering Act. I am very sure Section 19 of the Prevention of Money Laundering Act is a section wherein safeguards are provided already with respect to arrest. When a person is arrested, it presupposes a condition that DOE, that is a Directorate of Enforcement, has material in possession which leads to reason to believe, and mere suspicious cannot be the basis for arrest under Section 19 of the Prevention of Money Laundering Act. Even though Section 19 has been upheld as constitutional in Vijay Madan Lal Chaudhary versus Union of India. So this being referred to the constitutional bench as a wide implication with respect to arrest provisions under the Prevention of Money Laundering Act. My dear friends, arrest under the anti-money laundering law across the world has same kind of implication. Considering the fact anti-money laundering law is very strict in other countries also, there is an FATF regulation. So considering all these factors, Section 19 of the Prevention of Money Laundering Act has been referred to the constitutional bench, especially through the observation by the Supreme Court when interim bail is granted to Arvind Kejriwal, the Chief Minister of Delhi. My dear friends, in Prevention of Money Laundering Act, Section 19 with respect to the power of arrest, Section 45 regarding the bail, and Section 15 under Prevention of Money Laundering Act, Section 19, Section 45 with respect to under Prevention of Money Laundering Act 2002, Section 19 power to arrest, Section 45 with respect to bail, and Section 50 with respect to power to issue summons has wide implication with respect to the investigation. This being the bedrock of the Prevention of Money Laundering Act. All three sections are the bedrock of the Prevention of Money Laundering Act. Section 19 being referred to constitutional bench of the Supreme Court has a far-reaching implication when it is being questioned through the constitutional provisions in the days to come. We are all looking forward to see what are the kind of arguments that are going to take place with respect to Section 19 in the days to come before the constitutional bench of the Supreme Court. My dear friends, while granting interim bail to Arvind Kejriwal, Chief Minister of Delhi, Supreme Court made very important observation with respect to Section 19 of the Prevention of Money Laundering Act 2002. My dear friends, we all know Section 19 of the Prevention of Money Laundering Act 2002 deals with power of arrest by the Enforcement Directorate officers. But the most important observation that has come from the Supreme Court, from the bench of the Supreme Court, comprising Lordship Justice Sanjeev Khanna and Lordship Justice Dipendra Datta, is that wherein they very clearly said there should be material in possession. That material in possession should be the basis for forming reason to believe. And this reason to believe is not equal to mere grave suspicion. Mere grave suspicion is not equal to reason to believe. Accordingly, the reason to believe should be recorded in writing and the arrestee is guilty. Essence of Section 19 of the Prevention of Money Laundering Act 2002. But most important observation that has come from the Supreme Court, while the most important observation that has come from the Supreme Court with respect to Section 19 is need and necessity of arrest. My dear friends, this need and necessity of arrest, even though it is not found in Section 19 of the Prevention of Money Laundering Act 2002 with respect to power of arrest, but need and necessity is a very important ingredient for the purpose of arrest, is the observation of the Supreme Court while granting interim bail to Arvind Kejriwal. The need and necessity flows from the reason to believe recorded in writing. Power of arrest cannot be exercised merely for the purpose of interrogation and investigation. But the material in possession it is clearly observed by the Supreme Court that power of arrest cannot be exercised for investigation alone. But there should be a material in possession giving rise to reason to believe. That reason to believe should be in writing, and that it should not be based on mere grave suspicion. My dear friends, this is an important development with respect to the Prevention of Money Laundering Act. As we all know, Prevention of Money Laundering Act, which came in 2005, is evolving now because the jurisprudence of Prevention of Money Laundering Act works in two-phased manner, wherein there should be a predicate offence. Based on the predicate offence, Prevention of Money Laundering Act the jurisprudence with respect to Prevention of Money Laundering Act works in two phases. In first phase, there will be a predicate offence, and in the second phase, there will be an investigation from the Prevention of Money Laundering Act. My dear friends, as we all know, Prevention of Money Laundering Act 2002, which came into effect in 2005, is an evolving legislation, wherein Section 19 being a most draconian section of the Prevention of Money Laundering Act, Supreme Court's observation at this juncture is very, very crucial. My dear friends, you all know very well that under the Prevention of Money Laundering Act, investigation is possible only when an offence is a scheduled offence. That is, there should be a predicate offence. That offence should be listed as part of the Prevention of Money Laundering Act schedule, and then it becomes a scheduled offence. Only when it's a scheduled offence, then the investigation is possible under the Prevention of Money Laundering Act 2002. In case of Arvind Kejriwal, the Chief Minister of Delhi, it is a Delhi liquor case, wherein CBI has registered the case under the Prevention of Corruption Act 1988. Of course, even though Supreme Court has granted interim bail to Arvind Kejriwal under Prevention of Money Laundering Act 2002 as per Section 45, however, Arvind Kejriwal is still in custody because arrested under Prevention of Corruption Act, that is for the purpose of CBI investigation. That is the predicate offence. My dear friends, so in this evolving jurisprudence, it is very important that arrest provisions under the Prevention of Money Laundering Act is referred to the larger bench on the question of doctrine of proportionality. The doctrine of proportionality is referred with respect to Section 19 of the Prevention of Money Laundering Act to the larger bench of the Supreme Court. In the days to come, I am very sure Section 19 is going to be deliberated in the Supreme Court. Many more observations are expected from the Supreme Court, and many more petitions will be filed, and many more petitions will also be filed from across the country questioning Section 19 of the Prevention of Money Laundering Act 2002. My dear friends, from the international perspective, anti-money laundering legislations across the world is very strict. But however, the three sections in India, Section 19 dealing with power of arrest, Section 45 dealing with bail, Section 50 dealing with summons, as its evolution from FATF requirement. Even though India is ranked high FATF ranking with respect to implementing anti-money laundering legislation, but however, point to be noted here is that arrest provisions are now being referred to the larger bench of the Supreme Court, definitely questions the need and necessity of the arrest under Section 19 of the Prevention of Money Laundering Act 2002. My dear friends, in the days to come, many more constitutional questions will be asked from the perspective of Prevention of Money Laundering Act 2002. As we all know, three-bench judge of the Supreme Court in case of Vijay Vadalal versus Union of India clearly said Section 19 is constitutional. Section 19 of the Prevention of Money Laundering Act 2002 is constitutional. However, while the interim bail is being granted to the Arvind Kejriwal, now the larger question of doctrine of proportionality with respect to Section 19 is referred to the constitutional bench. So, in the days to come, the questions of arrest, the principles of arrest, and the safeguards within Section 19 of the Prevention of Money Laundering Act will definitely be deliberated in the Supreme Court as part of the larger bench, and many more observations are expected from the perspective of Section 19 of the Prevention of Money Laundering Act 2002. Let's all wait and watch what's going to be the development in the Supreme Court in the days to come with respect to Section 19 of the Prevention of Money Laundering Act 2002. Thank you, my dear friends.